And our focus today will be the proposed amendments to the agreement and conditions of contract for building works, which is famously called the Green Book. Ideally, today's session, we are not going to be going too much into the nitty-gritty details. We're going to have an overview, and probably later on we can have in-depth sessions. But today is just to get a feel of what the Green Book is about and what the proposed amendments are seeking to achieve. Primarily, we'll be focusing on 4 thematic areas. Those are the variations, dispute resolution, extension of time, and the payments. But before I get started and introduce our very distinguished panel, I would like to introduce our president, Architect Mugure Njendu, to make some welcoming remarks. Karibu Mugure.
Thank you very much to the moderator, Vice President Wilson Mugambi, and to all the attendees who have joined us today. I'm very pleasantly surprised to see so many people join in. We have about 103 people who have logged in already, and we're looking forward to many more people joining us on this very vibrant conversation. As an association, the Architectural Association of Kenya is very excited to discuss this topic, particularly on the contract document that we typically use on site. In terms of the ease of doing business, a good contract agreement is one of the foremost things that's required for us to be able to do the work that we need to do as we manage our sites. So it's with pleasure to just welcome everybody to this conversation. We've continued to provide webinars that are hopefully being very relevant to you as our members. We appreciate as much feedback as possible in terms of what topics you'd like to see moving forward as we all try to remain resilient in this economy and amidst the pandemic as well. So welcome to all the attendees. A sincere thanks to all the panelists who are here with us today. We have a very distinguished group of professionals who will be discussing this topic, and we look forward as well to receiving questions from those in attendance. So karibuni sana. Thank you very much, Vice President Wilson, and over back to you. Asante.
Thank you very much, Architect Mugure Njendu, President AAK. I'll be your moderator for today, and my name, as you've heard, is Wilson Mugambi, Vice President of the Architectural Association of Kenya. At this juncture, before we get into the topic at hand, I would like to introduce our panelists. And in the nature of being a true gentleman, it's of course ladies first. And I'll start with Senator Architect Sylvia Mweni Kasanga, who is a practicing architect and arbitrator. She's a RIBA chartered architect, arbitrator, and with the Chartered Institute of Arbitrators, United Kingdom and Kenya. She has avidly served with the CIRB Kenya as an elected branch committee member. She holds an undergraduate degree from JQuat and a master's degree in business administration from USIU Africa. She has over 15 years of professional experience in the construction industry and is a founder and managing director of SciCam Solutions Limited, a company that deals with architectural consultancy. She is currently a nominated member of parliament in the Senate, representing youth and women, as well as an active advocate of mental health, human rights, alternative dispute resolution mechanisms, modern construction methods, and professionalism. Can you greet our attendees, Senator Kasanga?
Good afternoon, everyone. Thank you so much for that introduction. I'm very honored to be here.
Thank you. Thank you, Sylvia. Karibu sana. Next is a very well-known and distinguished professional. He's a quantity surveyor and an advocate, a very unique combination. He's QS Nyaga Bore Kithinji. He's a partner at Coastwise Associates and also an advocate with Nyaga B Kithinji and Advocates. He's also a lecturer at the University of Nairobi, and he's also a practicing arbitrator. Karibu sana QS Kithinji. Say hi to everyone.
Still coming. Thank you very much, Vice President. Good afternoon, everybody. I'm Jambo, karibuni sana. And that's it for saying hi.
Thank you very much. Thank you very much. With us, we also have an advocate, Simon Kiriba, who is associate at Bowman, Kotsi and Hani. Advocate Kiriba, you can say hi to everyone.
Good afternoon, everyone. It's an honor and a pleasure to be here, and I look forward to the discussions that we're going to have today.
Thank you, Simon. We also have another QS, QS Mwai Mavenge. He is the principal of Willicon Associates, quantity surveying and alternative dispute resolution firm. He possesses a Bachelor of Arts in Building Economics from the University of Nairobi, and also a postgraduate diploma in law from the Kenya School of Law and a Bachelor of Laws from the University of Nairobi. He also has a Master's of Law in Construction Law and Practice, from which he got a distinction. He's also an advocate of the High Court of Kenya, practicing QS and arbitrator with the Chartered Institute of Arbitrators. And he's associated with several professional bodies such as LSK, Advocates Benevolent Association, Chartered Institute of Arbitrators, of course AAK, IQSK, Kenya Institute of Supplies Management, and also Institute of Directors of Kenya. Just by way of introduction, he was part of the team that drafted the current 1999 JBC Green Book that we have been using. And he was also part and chair of the team, or the former drafting team, that has come up with the Jbcc 2020 standard contract document that is a topic of discussion today. Karibu sana QS Mwai Mavenge, you can say to everyone.
Hello, everyone. Can you hear me?
Yes, we can hear you.
Yeah, Madam President and all President, all protocols observed. It's a good afternoon that we are here to do something that we started a while back. And we hope to be able to be of service to the industry as we do this today. Thank you very much.
Our other panelist is an architect. He goes by the name of architect Mushiri Waititu. He's an architect and director at Adventist In-House Africa Architects. He's also director at Jbcc and is a developer at Thumb Green Holdings. Architect Waititu, salimia our attendees. Karibu sana.
Thank you, Wilson. It's an honor and a pleasure to be here with you guys today. It's taken a while to reach this stage, and I look forward to hearing the opinions of others on this great contract that we're putting together. Thank you.
Right. Thank you, Architect Waititu. And last but not least, the reason why I'm introducing him last is that he's actually at the helm of the Jbcc. His name is Cairo Basha. He's a QS with over 35 years postgraduate experience, 31 of which have been in private practice. He's the founder and current team leader of Master Bill Integrated Projects and Project Management. He's active in alternative dispute resolution with experience of over 25 years. Of course, apart from being current chairman of Jbcc, he's also an executive director of KenGen, and he's actually a past chairman of AAK. Karibu sana QS Cairo Basha, salimia the attendees.
Thank you. Good afternoon, everybody. It is my great pleasure to be able to have the privilege of appearing before you. I am extremely excited, and I'm hoping that I understand there are over 200 attendees, and I'm hoping that there is well-distributed representation. And I'm saying this knowing very well that this is a webinar for AAK, which is primarily architects and quantity surveyors and some other chapters, but I'm hoping that we also have people from the developers and contractors representation. Thank you.
Thank you very much, Cairo Basha. And just by way of reiterating what I mentioned, is that this session is ideally to get a feel of the document, because I know we already have several people who have several opinions about the document. They've read it from beginning to the end and back. But we just wanted to get an overview of thematic areas and also just to get an understanding of what brought us to this point of revising the Green Book. And it wasn't deliberate, it wasn't an accident that I was introducing QS Cairo Basha last, because the next few minutes is for him to give an introduction and basically give some remarks about Jbcc and where it has come from, and just a quick recap of the journey that has got us here. Karibu sana QS Cairo Basha, over to you.
Thank you very much, Moderator Mugambi. I hope everybody can hear me. I can see that my I'm muted. No. It's okay. Can you hear me?
Yes, we can hear you. Go ahead.
Okay, thank you very much. I think it's very important that I narrate very briefly the history of this JBCC, so that even as we make our contribution, we take things into context. Many of you may or may not be aware that the book we are currently using, popularly referred to as the Green Book, was published in 1999. This is well over 21 years ago. Suffices to say that that nice, simple, and very good standard form of contract has served us very, very well. But over time, as the industry operating environment keeps on changes, it has actually been overtaken by events, and it has lost a lot of traction as far as preference by users is concerned. This is because when it was done, the industry used to operate in a particular way, but we are all aware that over the last 21 years, the landscape has really changed. And hence the decision of Jbcc with its partners, then AAK and CAPSEC, to start to embark on a journey to start to review this particular standard form of contract. This journey started over 3 years ago, that is 2017, and it culminated in several stakeholders forums, which actually came up with a resolution that we should review this document so that it can serve the industry, current industry effectively. It also selected a group of 4, in fact, it was 5 drafters. And the drafters, I think, have been introduced, but maybe it is my honor to mention them personally. The first one was Moi Madenge. The other one was Dr. Kiva. Then there was Sylvester Mudaria, and there is Kiriba, who is with us today. So fortunately, 2 of those drafters are with us today. These drafters worked extremely well on this onerous task. And at the end of about 2 years, they delivered what we then called a zero draft. This zero draft was a collation of all the views given by the stakeholders and recommendations for changes that should be considered for having the revised JBCC draft contract. You're aware that ideally, a team of drafters should have representation from all the stakeholders in the particular industry. But due to lack of capacity then, as these people knew this was going to be a very tough job, we did not get enough volunteers to carry out on this onerous task. So we ended up with only 4 drafters. That was Moi Madenge, Sylvester Mudaria, and Kiriba, and Kiva. And I sat with them occasionally as a next official member of that, because this task was being done under the leadership or guidance of Jbcc, of which I was the chair. As you can therefore see, unfortunately, and not intentionally, the drafting team was heavily skewed toward just having the professionals, because you see Moi, Mudaria, Kiva are QSs, and Kiriba is an advocate. But nevertheless, having said that, they did do a very, very good job, and they came up with that particular draft. But having said that, it is also important to point out that the recommendations made by this drafting team were based on the views forwarded by the stakeholders as at the time they were doing the draft. But it is obvious that for one reason or the other, not all stakeholders were able to present their views at that particular time. Therefore, we can be able to say that those particular recommendations that have been made by the drafting team are by no means a representation of the views of all the stakeholders. In fact, as recently as today, I'm still getting recommendations from people that we should include their stakeholders. For example, I've just had a conversation with Borat, who have told me, Chairman, we had recommended to be included amongst the appointing authorities in arbitration. Has that been done? Obviously, they are not there, but I told him I'm very, very glad to hear that. Put it in writing and it will be considered and we see what we can do. Therefore, we can say, however, having said that, we are aware that this process cannot be open-ended. And at one time we have to say, now these are the views that we have collected. And it is my humble submission that until the day we decide, now this is the draft that we are going to publish, we should not lock out any views from any stakeholder on account that the views have been brought out late. It will only be late. Consider your views when we say, we are sorry, we have gone too far, we cannot now change anything. Suffices to say that now this window is just about to close. And I'm hoping from the discussions that we have today, it will spur some of the people who may not have been able to air the views, to be able to think about what they've had and probably make some recommendations. I think, thank you very much, moderator. I think I will stop there at the moment. Thank you.
Thank you very much to Oskar Basha, Chairman Jbcc. I'm sure you will have several questions directed at you in our Q&A session. This is just a reminder to all our attendees that we have a Q&A panel, and you can post your questions there as we move along, and I'll be picking up the questions to be answered by the panelists. Next, to give us just a brief overview of how the drafting process went on and kind of consultations they had is QS Mai Modenge, who shall now give an overview of that process in the next 5 or so minutes. Karibu sana, QS Modenge.
You can see me? Can you see me? You can hear me?
Yes, we can see you. Proceed.
Yeah, okay.
Loud and clear.
Thank you very much, Mr. Moderator. I won't go into the genesis because Mr. Cairo has really done justice to that area. So I'll go straight to how we went about the task we undertook as drafters. Conferences were held by the stakeholders to decide on how the review would be carried out, mainly in 2018, starting around February. And it culminated in our appointment as the drafting team for the stakeholders for this JBC Green Book review. From direct instructions in the formal meetings and from other meetings when we were briefing the stakeholders, it became clear to us that amongst all the stakeholders, there was a theme about the kind of document they expected. And therefore, we as a drafting team reduced that into achievable objectives. And I will highlight them so that you can see in the end what we have achieved and what, even when we go ahead and amend and make recommendations for amendment, I want to take you to where we began and what we meant to do. The stakeholders from those meetings and direct instructions asked us to review all the provisions of the Green Book and come up with the following kind of a document: a more user-friendly contract, a contract with a better balance of power between the employer and the contractor, a document that expeditiously and effectively deals with contractual issues as they arise rather than waiting until the end, until they become a crisis, a document that minimizes full-fledged disputes or even avoids them if that is possible, a document that provides better accountability from those administering the contract and the parties too, a simple document without prejudice to any real needs for detail on rights and obligations of the parties under the contract. It was also necessary for us to come up with a more collaborative document so that the parties are not too far apart when they are working together to achieve the same objective of completing the project, even if it is for different reasons. We were also required very, very specifically, and there is one I would say it was very specific, to limit the review of the Green Book to only the amendment of the Green Book as a build-only contract with the quantities, and that other additional forms of contract would follow in the future after completing this exercise. So we were not to mix up with other types of forms of document. We were to retain the core of the Green Book and its character, and ensure that we dealt with the concerns that are highlighted up there. So we went ahead, we started our meetings in March. The drafting team held a review and research meetings at Bowman's. We were hosted by a very, very good firm of advocates between February 2018 to November 2018, when most of the drafting took place. And during this period, we received tons of memoranda from professionals, from the institutional stakeholders, and even from others who are not professionals, but they are stakeholders as identified by the chairman of JBC last time. On 29th of November 2018, we were called to present to stakeholders the draft that we had completed within the last 7 to 8 months, after considering all the views and other things that I'll mention as I finish, so that the stakeholders could give us a feedback on what they thought about the draft. During the meeting where a lot of the stakeholders were represented, certain areas where the drafting team could not settle because of different views about how we interpreted what the stakeholders wanted and our own personal knowledge and experience, we presented a set of issues that we asked the stakeholders in that conference of 29 November 2018 to give the way forward, because there was a gap between the drafters. That was done, and this was achieved through discussion during the plenary of that meeting of 29 November 2018, and direction on the way forward given through recorded resolutions. And we were informed in that meeting that anything that had not been raised as an issue by the stakeholders in the plenary, plus the issues we submitted to them for direction where we had not failed, but we could not have reached, had not reached agreement, we were told to proceed with the rest of the draft as it was presented. That was end of November, and therefore December interfered with the process because of holidays and people closing sometimes early in the month and others in the middle of the month. And therefore we restarted again towards the end of February the following year, 2019. In between, our repository for memoranda and other issues regarding the drafting, that is Bowman's, read by Alex Jaggi and Kireva, more memoranda from different people, and even those who had presented memoranda before by the 29th of December 2015 was received by our repository for those memos, who was Bowman's again. And we had to go back and revisit some of the issues we had already concluded in the draft that we presented on 29th November 2018. We therefore again took some time, but I must admit at some stage, we lost quite a bit of ground in terms of time, because one of the things that really affected this was fatigue. We had become a little fatigued. So between March and May 2019, that is last year, we lost probably about 2 months. And then we restarted again to continue with where we had left off, including the new issues raised by people who had even raised these issues 3-4 times before. But nevertheless, we proceeded. At one time, I remember Mr. Cairo was very unhappy because we kept going on and receiving more information, and sometimes not being able to meet certain deadlines that we would agree on the phone, because he was always constantly monitoring what we were doing. The drafting team based the review primarily first on the Green Book itself, and secondly, the written memoranda from institutional stakeholders, private consultants or individuals, the applicable laws for a contract of this nature, construction and building textbooks, construction law textbooks, other popularly used standard form contracts, and our own knowledge and experience. Lastly and not least, we had been requested by almost every stakeholder to benchmark what you are coming up with, even if you are not to be copycats, with other best practices documents from popularly used standard form contracts. And we went on and also did that, but of course we were very careful not to infringe on any copyright laws or anything like that. And I remember one time, one person decided, had asked me, just change FIDIC and it becomes the new green book. And you say, no, you know what you are doing and what you are asked to do. So eventually, on 4th September 2019, we were able to deliver to the chairman of JBC for circulation to the rest of stakeholders our zero draft. After another 13 different drafts of the same work, and therefore that is where we are today. You will find that in that draft, you could even find certain mistakes and obvious issues with even some language and description here and there, but that is the normal thing with drafting. You can never really see your own mistakes, even if you repeat and check that out. So we eventually expect that once it is agreed that with any amendments that may follow from any recommendations from all the stakeholders, you will find that you probably need some form of an editor. No, you need an editor to deal even with some very serious mistakes that you may not think one can make, but it so happens. With that, I add this, but I think I should mention that in total, apart from the 4 drafters, we had another assisting counsel, normally 2 or 3, again provided by Bowmans in their offices where we sat day and night, and we eventually spent about 2,600 hours combined. The drafters, almost about 2,000, and then the fallback position when they would go back to key in what they were recording, because we were being recorded verbatim as we did this work, plus the other stuff in the computers. By that very, very helpful stuff. I dare say without that stuff, we'd probably have taken another 6 months to be able to produce a zero draft. With that, Chairman, I hope I have delivered the overview on how the process went on. Thank you very much.
Thank you very much, QS Madenge. I think summarizing that timeline within 10 minutes was quite a task, and you've done it justice. Thank you very much. As you can see, ladies and gentlemen, a lot went into not only planning, but also executing the review process. And right now where we are, it's still an ongoing and sort of a final phase. Allow me to mention that we are not in any way having this session to endorse the document. We are actually using this session to learn where we can improve and what we can actually plug in or what we can remove from the document. So as much as it's an overview, I can already see several comments. Engineers have already started speaking. We are going to handle all of those in the Q&A session. At this point, I'd like us to go into the thematic areas that I had mentioned. I'll just remind you, there are 4 main areas we'll be touching on, with each speaker getting about 15 minutes. We have the variations, dispute resolution, extension of time, and payments or rather payments. So to start us off, the Senator Architect Sylvia Kasanga will be handling the variations. And of course, none of these presenters are going to be talking about endorsing or actually trying to force down anyone's throat what this document is about. They're actually going to even give us our own view, and that's why we wanted an expert panel to actually inform the exercise. So without much further ado, karibu sana, Senator Kasanga.
Thank you so much, Mugambi, and thank you everyone. Like I said, I'm very honored to address this team of distinguished stakeholders, my colleagues. And I'll be handling variations. I hope in front of you, hopefully you have the standard contract that we usually use, which is the book. And I hope you have the proposal that we shall be looking at today. So I shall be referring to both of them interchangeably. And Mugambi, I think when my time comes, just let me know and I'll just stop at that point. So I'll try and be swift as far as I can be. So fellow stakeholders, Variations, we know, are the most inevitable during our construction contracts. We expect them, and it's good to see and to hear what the process was during the drafting of this proposal, because actually I'm happy not too much has changed from the original contract document, because in my view, it was actually well encompassing, and some of the faults that happen and create a lot of conflicts in the industry is because of our own interpretation, probably not reading deeply into the contract itself. A few of the amendments that are being proposed are actually very good, because they remove the clouds that are in certain sections of this variations part of it. And to go right into it, if you look at the original contract under 30, variation comes under clause 30. It runs from clause 30.1 through to 30.14, and in the new proposal, it's actually on clause 29, running from 29.1 through to 29.1. So some of the salient proposals that are coming out, we see them, like for instance in 30.1, if you read what is being proposed, there are few inclusions into that clause that help to strengthen how we look at variations. And I'll read very quickly. The term variation as used in these conditions shall mean alteration or modification of design quality, quantity, or the agreed sequence of execution of works, something that wasn't there before, as shown upon the contract drawings and described or referred to in the contract bill specification program of works, and then it continues. So we are seeing there an inclusion on the agreed sequence of execution of works, as well as the program of works. As we know, those are two important areas where variations usually occur, and it was not there in the original document. So I believe that's a good inclusion, and it continues. The other one that I have looked at, of course, is 30.2, which is actually 0.2. The clauses actually follow each other, only that one is 30 and one is 29. So 30.2, the architect may issue instructions requiring a variation, and he may approve in writing any variation made by the contractor otherwise than pursuant to an instruction of the architect, provided always that such instructions that may change the object of the contract shall not be issued without the consent of the employer. Here we see an emphasis on the consent of the employer. We've seen in a lot of the disputes that we have, employers run away from variations that have been made. So here we are asking that architects, quantity surveyors must make sure they have the consent of the employer. In the next one, in the next clause, which is 0.3, actually 0.3 and 0.4 have sort of merged and expanded in the new proposal. And it is very clear why. If we just do a quick reading of 0.3, it says if the net value of all variations should amount to an increase of 20% of the contract price. The 20% of the contract price being a very relative and important proposal compared to what there was before, which was if the net of all variations should equal 15% of builder's works. In the original document, they talk of builder's works, 15%. And that can be misinterpreted or interpreted in a manner that may not actually be encompassing of the intended variations. Whereas in the new proposal, we see 20% of contract price, which I think gives a lot of clarity to that particular issue. And the rest of it actually continues as it is. If I read further on the 0.3 of the new contract, maybe I should read the whole clause. If the net clause of all variations should amount to an increase of 20% of the contract price, the architect shall not issue any further instructions requiring a variation for additional work without the written consent of the employer and the contractor. The QS and the contractor shall inform the employer and the architect in writing when variations reach their threshold, where the cumulative sum of the variations attain 20% of the contract price, the contractor shall not be bound to execute any further variations without the written consent of the employer. So we see also a further a further emphasis on the consent of the employer where the thresholds have been exceeded of variations. Then the next clause, we see also another deeper clarity being sought when it comes to this issue of 20% of the contract price, where it says all instructions for variations shall be copied to the employer and the QS, and where such variations will result in change in contract price, the value shall be assessed by the quantity surveyor, agreed with the contractor, and communicated to the employer and the architect prior to execution. So I see those two clauses will bring a lot of clarity, first also into the process, second into the threshold of the contract price, which is at 20% net value of all variations. Then also it brings clarity to how the contractor shall be communicated to, and also what the contractor needs to do when such thresholds have been reached. When we move on to the next clauses, that is in the original contract 30.5, we see again another slight adjustment to this. In fact, we see an introduction of timelines, and we know when it comes to when are the issues of variations going to be brought up. Abby, please. Where? Sorry, I have my daughter here. Sorry, forgive me for that. So the net value, all variations required by architect and subsequently sanctioned by him in writing, and all work executed by the contractor for provisional sums that are included in the contract bills, I'll skip that, shall be assessed by the QS, who shall give to the contractor a reasonable opportunity of being present at the time of such assessment and of taking notes and measurements as the contractor may require. The assessment shall be carried out with 30 days of execution of the works. We've seen many times issues of variation being brought in towards the end of a project, and this creates a lot of disputes, because then there's, you know, where is it being brought at this time, who okayed the variation. So I think this introduction of the timeline is very critical when it comes to the conflicts that come with it. The next few clauses have been retained as the same, save for 0.62. If you look at 30.62, there's a slight amendment that has been proposed there. And in fact, this is to do with the quantity surveyor who shall give the contractor an opportunity of being present at such evaluation. For this is again to avoid any issues of conflict that come during quantifying of variations. Make sure that the contractor is part of the process of the valuation of that variation, which I think is very, very critical in addressing the disputes that come out of these things. So the next clause has been retained, which I appreciate, save for 30.6.4. If you look at 30.6.4, in the new proposal, again, a lot of clarity is being proposed in this one. And I'll just read it as it is in the original document. The prices in the bills shall determine the valuations of items omitted. So in this particular case, these are variations for items that have been omitted, provided that if omissions substantially vary the conditions under which the remaining items of work are carried out, the prices of such remaining items shall be valued as set out in higher clauses. In the new proposal, it goes, the prices in the contract bills shall determine the valuations of items omitted, provided that, and I think this is good because it gives really a lot of clarity in how then we should handle omissions, which we see a lot in our contracts. It adds two sub-clauses, A and B, and in A, it talks about if omissions have exceeded 25% of the contract price, then the QS shall notify the employer, the architect, and the contractor in writing within 30 days of attaining such excess. Again, something we have to appreciate in this proposal is the timelines that are now being provided. It is within those timelines, if the contractor or if such communication then is not done within such timelines, then of course it's put off. That way, then we don't have situations that arise during the final account as we usually see. Then upon application by the contractor to the QS, the quantity surveyor shall value the prices for such remaining items as set out in the higher clauses within 30 days of that application. And then the QS shall notify the employer, contractor, and architect in writing of the effect on the contract price. And all that has to be done now within 14 days. So an emphasis on timelines, an emphasis on the percentage of contract price, the threshold, in other words, the threshold upon which omissions have to be notified to all to all the stakeholders within the contract. Then on the second subclause on this one, it says if omissions substantially vary the conditions under which the remaining items of work are carried out, the contractor shall submit a detailed application to the architect, justifying the need for a fair valuation of remaining work. I like this one because it makes the contractor now have to really be on top of his things. And we know a lot of our contractors who are never quite on top of their contract details. In this case, the contractor really has to give a justification for any variation that comes now under this clause, which is good. A detailed application. I usually see this in the FIDIC contract, and I think it's very much appreciated that every time the contractor must put a case, it should not just be automatic. Some variations may actually help him in other ways rather than create losses and things like that. So there has to be a detailed application, justifying whatever fair valuation he may be. So the architect, upon receipt of such an application, shall evaluate and notify the QS, contractor, and employer within 14 days of the merits of that application and the grounds thereof. So again, we see a lot of clarity being brought into this process of omissions, and I think that is a positive thing on this proposal. All right, moving on, clause point 7 is retained as it is from the old Green Book. And clause point 8 is also retained as it is, so I really don't need to go into that. Clause point 9, there's a bit of adjustment there, either a collapse of point 9 and point 10, in a way just to clean up the language. It's just a matter of cleaning up the language, and I think the hope of consolidating. They were trying to consolidate, but the import of the two clauses actually does remain the same. One may be a typo where no instructions for variation shall be assessed. Could have been probably a typo, but I think it was just a collapse of the variation clauses in that sense. The other very critical proposal that is being made to the variations, I see it in clause point 1(2), where in the original contract, it reads, except as expressly stated in the contract, the architect shall have no authority to alter or amend the terms and conditions of the contract or to relieve the contractor of his obligations under this contract. But in the new proposal, I think we see a little bit deeper. Sorry, where the architect? Sorry, that is to do with the performance bond. The collapsing of the clauses, yes, brought in a few others. I think the one for the performance bond is point 1(3), whereas in the new contract, in the new proposal is point 1(2), and that is the one where there's a bit of clarity also brought into the proposal. If I may read, where the architect, with the consent of the employer and the contractor, issues instructions requiring a variation beyond the limit provided in the upper clauses, the employer may require an additional performance bond, and above that provided under the previous clause. The contractor shall be reimbursed for additional costs for the provision of additional bond upon a written application supporting details to the quantity surveyor, who shall assess, and the amounts so assessed shall be included in the subsequent payment certificate. So again, here we are seeing a situation where it doesn't just go, the contractor must bring in a justification for any adjustments that need to be made from the additional bond. Again, putting the contractor on the spot and making sure that he's on top of these issues and that things are not just taken for granted. Just because an additional bond is required, then you just go, the contractor just brings in an application for some extra costs. There must be supporting documentation and details for such things. And the last clause, under 30.1 the original document, we see also a significant proposed amendment on this one. And I shall read the original document first. The architect shall not issue an instruction requiring a variation for additional work exceeding 0.01% of the contract price without the prior approval of the employer, unless otherwise communicated. So we can see there a ceiling that has been put of 0.01% of the contract price. Whereas in the new in the proposal, the architect shall not issue an instruction requiring expenditure of any provisional sums exceeding 1% of the contract price without the written approval of the employer. On one hand, we were talking about 0.01 of contract price, and that has been now completely removed. Instead, we have 1% of the contract price for any provisional sums. So I think now the issue of provisional sums and variations is covered in this particular new proposal, something we did have in the original proposal. And also the issue of capping the ceiling that we had discussed a little bit earlier of 20% net value of all variations on the contract price. So we have the contract price covered in terms of the ceiling, and we have also the provisional sums that the proposal is to cap them at 1% of the contract price, beyond which now the architect must seek consent from the contractor and the client. So in a nutshell, those are some of the salient new proposals that have been made to strengthen the variations portion of our existing contract. And just a reiteration for us industry players is that even in the old document, the process of how to handle variations is fairly clear. And with these new amendments, some of them, it becomes even stronger, and it will help with mitigating, and stopping too many disputes. A lot of the disputes that come to us have to do with actually a poor handling of variations by all the stakeholders within the contract. So I think some of these are really good. Some I think will probably need to be looked into a little bit further. I personally, if I was to give my own personal view, I would say that 20% that is being given as a cap for the net value of all variations should amount to an increase of 20% of the contract price, then the architect shall not issue further. I would think 10% or the 15% would have still been adequate, especially when you think of large contracts, really large contracts. 20% may be on the higher side, but on the smaller contracts, it will work. So a balance there may be required. So that is my submission for today. And just also to just thank the team that has been working on this. It's not easy, but this is for posterity, and your patience is very commendable, and we really appreciate this industry players that you took your own personal time to do these things for us and for the future of the industry. So thank you very much. Back to you, Gandhi.
Thank you. Thank you very much, Senator Architect Sylvia Kasanga. I think that was a marathon, and you've done quite well to capture the salient points. I think the area of variation is something which I think every professional has to deal with on every site, and you've captured it well, and I'm sure there'll be a bit of Q&A with that. Asante sana. Before we move into the next panelist, I'd just like to clarify, there's been a question about the document that Senator Kasanga was referring to. That is the zero draft from the drafting committee. It's another document which also circulated, and to all attendees, it had various corrections, or other amendments in red. That one is yet to be considered by the drafting committee, but we welcome your views on the same, because we believe that the whole point of this exercise is whatever documents are out there, there's version 1, which was the zero draft from the drafting committee, and there's the other one which had the amendments in red. And I know the key point there is the contract administration issue. Feel free to comment about that, and we'll be definitely highlighting more in the Q&A session. Another thing we'll be doing is projecting, and I'll be asking the AAK Secretariat to project the document that that Senator Kasanga discussed. And as the next panelists proceed, we'll make sure that we try and keep up with them as to the areas they are highlighting. So AAK Secretariat, let's have those documents shared once each panelist is sharing their presentation. Next is the thematic area of dispute resolution. And for this, we have Advocate Simon Kiriba to give us an overview of the Green Book as it is, and as for the new amendments. So over to you, Advocate Kiriba. Karibu sana.
Thank you very much, Wilson, and thank you very much again to the participants. The dispute resolution clause, the amendments, you will see, sought to achieve a few principles that you will see as we move along. First is to come up with a process which provides for expeditious resolution of disputes. Number 2 is to come up with a more prescriptive provision relating to dispute resolution, that is closing any gaps whatsoever that may have been there in the previous document. Number 3, it's the dispute resolution process also sought to maintain the relationship between the contractor and the employer. And most importantly, the dispute resolution provisions and the procedures sought to ensure that dispute resolution happens in a way that the progress of works is not affected. And to that effect, I'll go straight into some of the differences between the Green Book 1999 and what I will be referring to as the Green Book 2020. I do hope that publishing can happen in the course of this year so that I will not be wrong. Anyway, so when you look at the 1999 Green Book, it primarily had 2 dispute resolution processes, and that is arbitration and amicable settlement. When you come to the 2020 proposed draft, it introduces a third process, which is adjudication. And adjudication is, roughly speaking, a process similar to arbitration, which provides a rough and ready justice expeditiously. And I would just comment, say that the introduction of the adjudication process in the Green Book 2020 was the first issue that was discussed and agreed upon by stakeholders in the very first stakeholders conference. And the voice of the industry as far as adjudication was concerned was a unanimous yes. And it is one of the very few issues that did not have varying views or opinions. And I believe in the industry, the industry confirmed that it was time that construction adjudication became part of the Jbcc framework and agreement. Some of the advantages of adjudication is that it provides faster dispute resolution. And then what I had mentioned as part of the principles is that it enables the project to proceed seamlessly so that dispute resolution can continue as the project is, as works are ongoing. It maintains relationships, and it also reduces the number of disputes that go to arbitration. Evidence indicates that disputes once canvassed reduce as you go up through the dispute resolution chain. Say, for instance, in our own courts, disputes that you may have more disputes at the magistrate court as opposed to the disputes that you get to the Supreme Court. So as you move up the dispute resolution chain and framework, the disputes do reduce. And this is important because it ensures that only the most serious and contentious disputes get to arbitration, and quite a bit of the disputes are sieved through the adjudication process. And I believe that this was a very good introduction by the stakeholders in the Green Book dispute resolution process. So essentially, the 2020 Green Book has 3 dispute resolution processes. Number 1 is adjudication, number 2 is amicable settlement, and number 3 is arbitration, in that order. And we can just take a step back to adjudication. Disputes generally begin with adjudication. I have used the word generally very intentionally, and you'll see why. And the kind of adjudication tribunal that the Green Book envisions is an ad hoc tribunal as opposed to a standing adjudication tribunal. And the difference here is that a standing adjudication tribunal is one that is appointed at the beginning of the project to run throughout the construction period. An ad hoc one is a tribunal that is appointed as and when a dispute arises. To ensure that disputes are resolved fast, a decision must be rendered within 30 days of appointment of an adjudicator, or at the very maximum within 45 days, that is an extra 15 days, in the event that the contractor and the employer agree with the adjudicator to extend that time of providing a decision. And you will see that that is one of the ways that the Green Book 2020 has tried to resolve disputes expeditiously. A key and a very important concept of adjudication that was introduced in the Green Book is that decisions of the adjudication tribunal are binding on issuance, and which essentially follows the concept of you pay now, argue later principle. And there is a framework where an aggrieved party is given 7 days to issue a notice of dissatisfaction. And if an aggrieved party or if no party has issued a notice of dissatisfaction within 7 days, then the decision of the adjudication tribunal becomes final and binding. The difference between binding and final is that a binding decision means that parties are bound to comply with the decision on issuance, whereas when the decision becomes final, it means that an aggrieved party has lost any right to refer the decision to arbitration, and the decision that was issued at that point becomes final and binding. And another process, the next process that is part of the 2020 Green Book is amicable settlement. And amicable settlement, you will notice, was also part of the 1999 Green Book. There are a few additions here and there, say for instance, providing the timelines for which amicable settlement should happen. And amicable settlement must be completed within 30 days from the commencement of the process. And there is also an addition on the Green Book 2020 to the effect that an amicable settlement agreement should be reduced into writing. And that is to avoid a situation of he said, she said. And that is also borrowing a little bit from the court annexed mediation, mediation rules, even though this amicable settlement here is not bound by these rules. And just to mention that two things about amicable settlement is that amicable settlement, according to the Green Book 2020, is that it can either be done by the parties on themselves, which would be negotiation or conciliation, or it can be done with the assistance of a third party. So that is where mediation is introduced into the Green Book. And then also to mention that generally parties have the right to amicable settlement at any point of the dispute, whether they are in adjudication, whether they are in arbitration. If the parties do decide to settle the dispute amicably, they maintain that right. And if they so do, then the other processes may be terminated. And the contract, the Green Book 2020 does not restrict the process of amicable settlement proceeding at any one point in time. The next dispute resolution process that is provided for in the Green Book 2020 is arbitration. And in arbitration, you will notice that the draft proposes two kinds of arbitration. One, there is emergency arbitration, and then two, there is ordinary arbitration. And if you remember, I said that all disputes generally start with adjudication, and the reason why I stated they generally begin with adjudication is because on issues relating with some matters that go to emergency arbitration, those do not begin with adjudication. They go straight to emergency arbitration. And some of these issues relate to something like, say, for instance, validity of the contract, the validity of the architect's instructions, withholding of payment certificates, etc. And you will see that the rationale of having emergency arbitration is that it is to provide resolution with finality urgently for the purposes of progress of the works. Going back to some of the principles that were guiding the entire drafting process, so that this, when a question relating to an architect's instruction arises, it does not need to go to the whole process of appointing an adjudicator. An adjudicator hears and receives evidence from both parties, issues a decision within 30 days, and then after that, once a decision has been issued by the adjudicator, an aggrieved party issues a notice of dissatisfaction, and then going all the way to arbitration. So on an issue such as the validity of an architect's instruction, which is necessary for progress of works, it was felt by the stakeholders that the best thing to do is you deal with these kind of issues with finality and urgently. And to that effect, emergency arbitration as provided for in the Green Book 2020, a decision is rendered within 15 days from the appointment of the emergency arbitrator. And also to mention that the decision of the emergency arbitrator is a final decision and it is not an interim relief. It's not a question of an injunction. And to that effect, the Green Book 2020 distinguishes as a matter of concept between emergency arbitration in the Green Book vis-a-vis emergency arbitration as provided for within the NCIA arbitration rules. Under the NCIA, the Nairobi Center of International Arbitration rules, emergency arbitration is usually seen as an interim relief as you wait to, as parties wait to canvass their dispute in the ordinary arbitration process. So just to repeat that, emergency arbitration is a final decision and not an interim relief. And the emergency arbitration process, in addition to the elaborate provisions that are provided for in the Green Book, would also be guided by the Chartered Institute of Arbitrators arbitration rules, which have a similar concept of what they refer to as simplified arbitration. And what the next kind of arbitration process that goes on is ordinary arbitration. Now, for ordinary arbitration, you will notice that all the other matters, apart from those which go to emergency arbitration, will first go to adjudication. And then after going to adjudication, if there is a notice of dissatisfaction that is issued within 10 days of issuance of the adjudicator's decision, then they would go to ordinary arbitration. One very important principle that we need to note as far as the Green Book 2020 is concerned, which borrowed from the 1999 Green Book, is that for ordinary arbitration, it can only happen after practical completion or after termination of the contract. So if, say, for instance, I go to adjudication and I'm dissatisfied with the decision of the adjudicator, and then I issue a notice of dissatisfaction within 7 days, and practical completion does not happen for another 3 months, I cannot start the arbitration process from that decision of the adjudicator until practical completion has been achieved. And to that effect, the contract provides for the mechanisms of how you commence disputes on ordinary arbitration, just as it does with all the rest. And one of the key elements is the provision of what is referred to as an arbitration notice, in addition to a notice of dissatisfaction. We also note that, I also note, sorry, that some disputes, if a dispute arises after practical completion, the aggrieved party has the option to either refer the dispute to adjudication or refer the dispute to ordinary arbitration, because this is happening after a practical completion. And you will see the thinking that is being reflected throughout these entire provisions, to the effect that because works are now substantially complete and they are functional, having an arbitration is not going to derail the progress of works, because what would be remaining at this point would probably be incomplete works, some minor incomplete works or rectification of defects. So having the parties be open to either go to dispute resolution, to adjudication, sorry, or to go to arbitration, that is also flowing from some of the principles that were guiding this entire drafting process. And then just to mention that a decision of the arbitrator is final, and it is not subject to appeal from any court, is not subject to any court, and such a decision can be presented to the High Court for enforcement. Something that that I left out when I was discussing adjudication as part of the benefits of adjudication, when we speak about civil disputes, is that when in instances where parties have entered into what is referred to as international arbitration with a seat, say for argument's sake, the ICC, what we usually see in practice is that if you have an adjudicator or an adjudication tribunal, most of rarely will you see disputes going to ICC and this kind of international arbitration, because they are very complex and they are very time consuming and they are also very, very expensive. So it makes sense for parties to canvass a dispute at the adjudication space before they can go all the way to international arbitration. And as mentioned before, if parties decide that they are going to go to arbitration after an adjudicator who is a suitably qualified adjudicator has given a decision, then it's going to be a dispute. It's going to be a serious dispute where an aggrieved party still feels that I have chances of success and what have you. And just to mention one other thing about adjudication is that we do have adjudicators in this country, and I think it's a privilege to note that some of the panelists, in fact, quite a number of the panelists in this webinar today are adjudicators who are very experienced in this field. And allow me to go back to the very final clause of the 2020 Green Book, closes with a somewhat thunderous warning, because it is a time bar provision, and it simply says that it says that if a party does not comply with the notice periods that are provided for within the arbitration, sorry, within the dispute resolution clause, then they will not be allowed to enjoy the benefits of dispute resolution within the contract, and the relevant party shall have lost its ability to claim from the party that is at fault, and the other party shall be deemed to have been discharged from its liability from such failure. And I think it is a very important clause to come at the very, very last subclause of the document, so that it's not hidden somewhere, so that parties are very, very much aware that the timelines that are provided for within the contract are a very serious issue. Again, there are some principles that are guiding this entire process. For instance, expeditious resolution of a dispute, which has serious consequences on the relevant dispute. I believe with that, we would have, that is the clause 44.5 that we can see there. I believe with that, you have the general principles, and you can be able to maneuver through the details of the clause 44, that is the dispute resolution provision. Thank you very much, and back to you, Chair.
Thank you very much, Simon. I know I'm really pushing you guys to summarize within 15-20 minutes, but it comes with the territory. We have to keep time at heart. But I think Advocate Kiluba has really captured the overview that we wanted to get. And my word, there's quite a bit of comments coming in. I'm sure as the panelists are also seeing them. So Q&A will be quite a hot session, for lack of a better term. I'd like us to move on quickly to the next item, which is a presentation on an overview of the extension of time. This will be done by QS Nyaga Kithinji. So over to you, QS Kithinji, without much further ado. Karibu sana.
Thank you very much, Chair. I greet you again, fellow professionals and stakeholders. I will run through the provision on the extension of time, which is clause 36 of the Green Book as we know it, and it is also clause 36 in the proposed amended draft, which is the Jbcc draft. And I will begin by explaining what this the effect of the extension of time clause on contracts. It is very important to contractors and to employers because it affects them in terms of their business. For the contractor, an extension of time or a denial of the same will affect their ability to claim loss and expense and extended preliminaries and such other time-related costs that go with construction contracts. And for the employer, and the extension of time clause also affects the ability to claim liquidated and ascertained damages or other business losses that may be incurred. And it also affects planning in terms of selling or letting or carrying out business in the premises that are being constructed. The clause has been maintained substantially as it is in the Green Book that we have currently, but there are a few things that have been introduced. If we look at the general theme of the clause, it deals with the method of application and granting of extension of time. It also deals with the reasons for the application and reasons for the granting or denial of extension of time. Then it looks at the involvement, who is involved and to what extent. And all the changes that have been proposed in the new document affect those areas. Okay, so we can begin. I'll run through clause by clause. Fortunately, there are very few areas that have been affected and I'll be able to move quite fast. The very first one, which is not even about the clause, of course, is that we are moving from the Green Book, which is a JBC document, and we are going to the new Green Book or whatever color it will be given, which will be a Jbcc document. So we have an additional C. And moving to the clause itself, the name of the clause has been changed. Initially, we had the extension of time as the heading of the clause, but presently we have adjustment of the intended date of practical completion. There are definitions which come at the beginning, which deal with some of the technical jargon used, and therefore I won't go into the jargon and the reasons for the change of jargon. And I'll then move to the clauses which have changed and the reasons for the change. The very first change has to do with reasons for application. That is clause 36.1. The initial clause read like, upon it becoming reasonably apparent that the progress of the work has been delayed. And the new clause is, upon it becoming reasonably apparent that the progress of the works is or is likely to be delayed. So that clause changes the starting point of application, and the contractor has an opportunity to make an application for adjustment of the intended date of practical completion when it becomes apparent that work is likely to be delayed. In fact, this is a correction of a language error, because going further down into the Green Book, it actually talks about if the architect finds that work is likely to be delayed or has been delayed. So it is a reconciliation of language. And I think clause 36.1 is a good relief that we begin right from the start of the provisions, that understanding that the contractor need not wait for a delay, but should be able to make an application when it becomes apparent that the work will be delayed. In fact, this does address another part of the contract, which says that if the contractor does not make an application within 30 days of it becoming apparent that work will be delayed, then he loses the opportunity. If then the contractor has to apply after noticing that work has been delayed, he could notice that when it is 60 days in delay, and you lose the opportunity to make that application or for the assessment of that application. So that's a welcome change. Now, the next clause 36.1.1 is about who gets involved. Initially, the application was meant in the, or rather presently with the Green Book as we know it, the application is meant to be made to the architect and copied to the employer. Practically, it is made to the architect, copied to the employer, and then the architect, for good reason, contractual reasons, makes a copy or forward the same to the quantity surveyor, so that in most cases the quantity surveyor would assist in giving a contractual interpretation and advising the architect to in what direction to move with the assessment of the application for extension of time. And what has happened now is that the contractor is required to make the application to the architect and copy both the employer and the quantity surveyor. So it makes it easier administratively, such that when the architect gets the application, all he needs to do is to call the quantity surveyor and call him to work. Say, you have this document, you can see what it is saying, please advise on this and the other area. Now, again, that clause is an extension of an existing one, and it introduces the idea of the contractor giving details to show the extent of delay caused or delay likely to be caused, which is again works very well with 36.1. The other clause which has changed is the clause number 36.1.3, and the change in that clause basically is to give the architect an opportunity to ask for better particulars from the contractor. This is not a new thing in practice. In fact, in most situations, when the contractor makes an application for extension of time, the architect will ordinarily write to the contractor and ask for better particulars in terms of the supporting information. So that has been brought in now, and it has also been given timelines, 14 days. Again, as you've been already told, this document is very, very strict on timelines, so that there are no processes which are left open-ended in terms of time. So the application has to be, I mean, the architect will inform the contractor within 14 days that there are further particulars required. Then the contractor will have to submit the information within 7 days. That's a new introduction. And then there is a caveat to the contractor in terms of specification or rather exclusion of site meeting minutes or any other minutes as reasons for a request for extension of time or adjustment of the intended completion date. The reason for this again is that the contractor must give reasons which have been made, applications which have been made in accordance with the process given, items which are agreed, because sometimes minutes of meetings are contentious. Ordinarily, we find that they are not even signed. And so this is a welcome, it is a welcome inclusion, so that the contractor is warned in good time that he cannot rely on minutes. In many situations, you note that, especially in arbitration, when minutes are brought to prove or disprove reasons for extension of time, the contractor will say that the minutes were doctored, the architect will say the minutes are not signed. So this is a welcome relief. At the 6.2 introduces is likely to be or has been delayed, which is in keeping with the theme of the contract. And that 6.2.15 introduces a word, just one word, which is important. This is with respect to the reasons, which have basically been kept as they are in the Green Book, present one, except for what I'll give you right after this one. In that 6.2.15, there is the introduction of the word demonstrable, so that the reason which is covered here reads, by reason of the contractor's demonstrable inability for reasons beyond his control to secure such skilled labor and other workmen essential to the proper carrying out of the works. And then the other reasons continue. Now, demonstrable here is calling the contractor to the duty of actually bringing reasons which can be verified. This word, in my view, can even be replaced with the word verifiable. It will mean the same thing, so that it is not just a theory. The reasons can easily be seen and they should speak for themselves. Going to that 6.218, there is a new reason which has been given for the application for adjustment of the intended completion date, which doesn't exist in the current one, and that is any other reasonable cause of delay that the contractor may, in the architect's opinion, justify. Well, there's a bit of English there which needs to be tweaked to read better, but any other reason. Now, any other reason is a big one, and this calls for exercise of discretion and on the part of the architect, but it is a very good reason, because the reasons that are given cannot be exhaustive, For example, if a contractor is working and then the president passes by and there are some over-enthusiastic officials who stop all work for 2 days to prepare, or for 3 days to prepare for the passing by of the president. What would that be in the reasons that we have been given? Nothing. So any other reason is a big reason, and I'm sure this one, as important as it is, will actually cause some disputes, because the architect will dispute some. For example, I lost a relative, and therefore I had to close to observe certain religious things about all this. And so arbitrators should be ready for some disputes on this clause. 36.3 has made an introduction, which is basically a drafting introduction, notwithstanding the provisions of subclause 36.1. The architect shall make a final decision on the application by the contractor within 30 days. That is to say, even if there is a request for better particulars, 30 days still remains. 30 days is what is in the current JBC. It says, despite the introduction of that part of a request for better particulars, 30 days still holds. There is a clause 36.5, which is a bit, in my view, of a misnomer, because whereas clause 36 is dedicated to the adjustment of the intended completion period, clause 36 introduces contract price, and it introduces quality of works, and it reads, the contractor shall continually assess any circumstances or situations that may adversely affect the contract price, the contract period, and or affect the quality of works, and notify the architect at the earliest opportunity of any such circumstances or situations. Going forward, I'll keep an eye of this clause. Something has to be done to it. Contract price, well, I will advocate for the striking out of the parts that are not dealing with time, and those should be taken to where they belong. Then there is clause 36.1. Clause 36.1 has introduced a window for review of the architect's decision on extension of time, or its new description as adjustment of the intended completion date, where any party that is dissatisfied with the decision of the architect on the adjustment of the completion time can make an application, can write to the architect introducing, setting out their dissatisfaction. And note at 36.10 that it says where the party is dissatisfied with the decision of the architect on adjustment of the intended date of practical completion, or the architect's failure to act under subclause 36.6. Now, there is a contradiction, because it begins taking away something from the provision of clause 36.6, which provides that on the 45th day of application, if the architect has not done anything, then the time applied for will take effect by operation of the contractual provision. But what this clause then says is that if, for example, the employer is dissatisfied with the architect's failure to act, and therefore bring into effect the extension of time by operation of the contract, then the employer can write to the architect, and then the architect can give his decision subsequent decision, that the 6.10.3, within the period provided in this clause. Now, that contradiction has to be reconciled because it gives an opportunity to reverse something which has already crystallized in terms of the contract. But otherwise, the procedure is good. It is necessary. It gives the opportunity primarily for the failure to act. That is a provision which I think only employers would be interested in. But for acting in a certain way, making a certain decision, then the two parties have an opportunity to address the architect and ask for a review, where the employer may feel that the architect has given more time than is justifiable, because remember the employer is copied on the application, and the employer may not be satisfied with some of the reasons given. The contractor may also be awarded time which he thinks is not sufficient given the reasons, and therefore it is again a welcome introduction, so that small disputes like those which may have extensive ramifications on one party or the other can be resolved when the information is fresh in the minds of the parties involved and the architect, and resolved at that point, so that again the contract becomes predictable. I wish to add that the theme of this document, and I have read all of it as I did some editorial work on it, is predictability and certainty. That everything has an opening time and a closing time. And if at the time of closure it is not concluded agreeably, it has a way of escalating it to the next level. And therefore, in terms of the clause for the adjustment of time, all those principles have been observed. And I think, save for the little things about the black sheep clause at the black sheep provisions at the 6.5, and a bit of a typo and the contradiction that I pointed out at clause that the 6.10, this clause appears to be good, and it has improved the current provision that we have, and it has made it quite certain and quite clear what needs to be done, at what time, by who, and at what time that process is closed and it moves to the next level. Thank you very much for listening to me. I now hand over to the chair.
Thank you very much, QS Kevinji. I think that's a very good overview of the extension of time clause. I can see there was some confusion as to the numbering, but I'll have you know that QS Kevinji was actually reading from the zero draft, the actual Word document, not the PDF that we have there. There was a bit of difference in formatting with what we have there. The zero draft actually had clause 36 being the extension of time. So I'm sorry about that, and I think the Secretariat will be able to share that as we move along. So next, without wasting any more time, so that we can go quickly into the Q&A session, I can see we already have 17 key questions which have been posted. Others are in chat, so I think we already have over 20 queries. So panelists, I hope you're ready for this. Let's have Architect Mushiri Waititu giving an overview of the payments clause. Karibu sana, Architect Mushiri.
Thank you very much, Honour Chairman. Mine, I'll deal with it architect style. We've gone through, like the other panelists have gone through their various issues. Mine is going to be a bit different. I'm going to deal particularly with what what we are trying to achieve with in pursuant of the clause regarding payment. So the first questions which we really asked ourselves is why amend? And the issue came up on the previous Green Book, the issues of process flow. That a document first is originated, a payment request is originated by the contractor. It goes to the QS for 7 days. Clause 34.2 stays with the architect for another 7 days. Clause 34.3, and the client has to pay within 14 days. Clause 34.5. So this is one of the issues which we're trying to address in the revised payment clauses. The second thing we wanted to address was to allow for advance payments. Advance payments have ordinarily, traditionally been a hot potato. Many times it became an ad hoc engagement. And so we've allowed for, I'll go into the clauses that we've introduced in my presentation ahead. So what we've done is just put good order into the issue pertaining to advance payments. The next one is the issue of dealing with disputes immediately via an adjudicator. So previously, what will happen, the QS gets a payment request, he works on it, raises a valuation to the architect. The architect may ask questions or not, but by the time it reaches the employer and it's time for him to pay, then you had a problem, and he had an issue about it. Say if the certificate was for 5 million shillings, he could raise issues with 2,000 shillings and immediately use that as an excuse not to pay. And we all in the industry, we know how this has resulted in a lot of delays, and it is a beginning of disputes. So what we've done is that we've allowed the adjudicator, who will be appointed at the beginning and he will be able to adjudicate, and there's a process which I will elaborate further. The fourth issue we're trying to deal with is just putting issues of retention in good order. We know that when the project is complete, even when it is going on, how the retention monies are usually banked. It is usually one of the things which is struck out first. The Jbcc has long advocated for people not to strike out that the whole document should be read in its entirety. But unfortunately, what has been happening is that the retention monies are usually cancelled out, and they're released at the discretion of the client. So we've put a lot of good order onto the issues of retention. And finally, number 5 is the issue of final accounts, that we now can be able to handle the final account process a bit more in a bit more straightforward manner. So if I can go into the issues of advance payment, we have now introduced, we've actively, this is a new clause completely, clause 33.1, and we have defined what the advance payment shall be. We know that contractors usually, they have to fund the project, then they are refunded later. And so the client inevitably ends up paying for the financing of the project by the contractor. So the contractor is getting his suppliers to give him money. So what we've allowed is that the advance payment is going to be, number 1, a sign of goodwill from the employer. and also to ensure that the contractor, can he advance better rates than he would have before? So 33.1 envisages this, and it gives you an opportunity to look at this as an interest-free loan to the contractor. And then 33.1.2, it goes ahead to spell that out, that it will be disbursed 30 days after the site handover. And then 33.1.2 and 3, it gives the contractors his obligations to give an advance performance guarantee and a performance bond. Yeah? These are all now, again, putting good order on in terms of the, with regards to the advance payment. Then we go ahead and in 33.1 from 4 to 10, these now go actively specify the terms of the guarantee. That is on the expiry, its extension, and the guarding against misuse of the advance payment. So if you can scroll that up, we can now go to the payment timing. Now, if you go to clause 33.4 to 33.6, these are, I'm not going to touch on clauses which really have not been amended or have no issues whatsoever. So I'm dealing with the clauses which have been amended, and you'll see 33.4 to 33.6. These now spell out the amount of time which from the time a contractor raises his application for payment till the time he's paid, what needs to be done. Now, usually there have been issues concerning how long it took to deliver, and sometimes the QS, for example, can say that I have not received this. I received this on this day when it was brought on a different day. Then sometimes also it can land on the architect, and he takes his 7 days and then disputes something. Then it goes back to day one. So this has just put some good order in how this will be done, in that the payment, if in the instance that there is no other issue, that the payment should be done within those 28 days. So it removes the previous Green Book was talking about 28 days in total. This one talks about 28 days maximum. Yeah, in so many words. Yeah? Then you go to 33.7. This is a new clause, and it particularly now deals with stage payments. So if the parties have agreed on stage payments, there are many such projects nowadays, and they've become a bit of the norm nowadays, because you're trying to manage an employer who does not quite understand the monthly stage payments, monthly payments, certificates. So if you're telling him that a wall has been done 33.5%, instead of doing this, there's the new way of doing things that you say substructure done. And if the substructure is done, then you have laid the slab. That is 100%. Superstructure, walling has been done, and you say it is 100%. So if you're doing stage payment, the first thing you'll need to do now is that you will need to annex a schedule of the agreed stage payments on this to the contract, where this will form part of the contract annex, where you're showing actively that and it is also pegged. So by the time you are handing over the site, these are the documents that should be exchanged. So, and one of them, this will actually form part of this. So the contractor only will come to claim payment upon completion of this stage. So this is a new clause, 33.7. The whole of it now spells out how that has been done. Then we go to 33.8, which is the employer's default on payment. Yeah. So if the employer refuses to pay upon the time which he's supposed to, now we've introduced a new clause, 33.8.1. It goes to specify that when the employer is in default, he'll actually be paying compound interest. Before it was just a simple interest on the time he was in default. Then 33.8.2, where the contractor is claiming interest, he needs to do so within 60 days of being entitled. Otherwise, then he'll have been deemed to have waived his right to the accrued interest on the affected certificate. 33.8.3, it gives the rate to be applied. And for this, we are saying that it will be 4 percentage points above central bank, or a rate which will be inserted in the appendix when the contract is being signed. Then 33.8.4 goes to give the methodology for payment to be done. So in this instance, the quantity surveyor is one who shall verify the amounts to be included in the next certificate because of the interest due to the delay. But again, note that the delays for payment are not going to be cause it does not give the contractor reason for delaying works until, of course, he raises the clauses which now affect the progress of works. So we go to clause 33.10, which now gives levels of dissatisfaction with a certificate. Now, before, and this has been a big cause for projects going to arbitration. So, what happens when either the employer or the contractor is dissatisfied with a certificate? So, 33.10.1 is when the employer is not happy with a certificate. Now we have introduced a new thing here, and it's called a pay less notice. Now the pay less notice is going to be issued by the employer when he does not agree to any of the amounts specified in the certificate. Yeah. So he issues a pay less notice, and he needs to issue it within 7 days of him receiving the interim payment certificate. So you notice that now it removes the problems that you have sometimes when an employer can refuse to pay a certificate in its entirety because of a very minor item. Yeah. So what should happen in this instance is that this takes care. If you have a certificate of 5 million shillings and you're disputing 20,000 shillings, then there is a pay less notice to that effect. Then 33.10.2 goes ahead to give the notice period for the pay less notice. Yeah. So he gives a 7-day notice, and then also 33.10.3 and 4 go ahead to give the pay less objection and the notice period that the contractor must give. So the contractor now, on receiving it, has 7 days to object to the pay less, to do a pay less objection notice, and then he needs to serve it to the employer and the architect within 7 days of receiving it. Then 33.10. Number 5 to 8 give periods of limitations to the employer and the contractor and how these should be framed. Yeah. So like 33.10.7, if the employer fails to serve a pay less notice or refer the matter to adjudication within the periods stipulated under 34.10 and 34.10.5, he shall be deemed to have accepted the interim payment certificate. So this removes the issues of we do a lot of housekeeping then on the employer and the contractor, so that they do not limit, they do not use their own inadequacies to delay payments to a contractor. Now, if there is still an objection, then all these issues then are escalated and issued to an adjudicator. That is the 33.10, 9 to 10, where now the adjudicator has received these, what is in dispute. Now remember that the adjudicator was appointed at the beginning of the project. So there is an adjudicator who is always on standby. If there's a dispute, it is escalated to him quickly. He resolves it, and if there's an issue, it is paid, either paid or deducted from the next payment, the next certificate. But you notice that now the payment processes are not slowed down at all by small disputes within the construction as they move on. Then you have number 6, which is the 33.18 and 19. And this is regarding the escrow account and its operations. Previously, like I said, this is a clause which is many times struck off. In fact, I've seen many projects when they're using the financing structure, they actually use the money for the retention as part of the financing. So in a roundabout way, you're saying that the contractor is actually the one funding the project to the retention amounts, if it's 10% or 5%. Now this one is now going, we are trying to put some good order on this. How? We are making sure that we have put housekeeping rules for the escrow, 33.19.1, and then we have put a very clear, in 33.19.1, the employer's interest in the retention amount shall be fiduciary, so that if there's any it should be clear that these amounts are for the contractor. Yeah. Why we have retention is that in the instance that the contractor does not deliver to the quality, it is a quality control mechanism. So when it doesn't deliver is when the employer may have recourse to that amount, but otherwise it belongs to the contractor. So it puts we've tried to put a lot of housekeeping issues, because what happens sometimes is, and what has been happening is that a lot of times after the project is complete, the employer is still retaining hold of the retention amounts. So 33.19.1 gives you a lot of housekeeping for the escrow. And then 33.19.2 gives you gives a very clear way of how this was not there in the original Green Book, but now it gives you a clear clear path of how you enforce the issue of moieties. So the first moiety, half of the amount, is released immediately, the issuance of the certificate of practical completion. And then as you wait for the liquidated damages period to elapse, then you have 33.19.2 B and C. B 1 and 2 remaining in force until the final certificate is issued. We have been having a lot of issues with the current. There's an NCA bill which was being put in about latent defects, and also that affects this. So I'm happy that has not gone. It is still in abeyance, but it doesn't look like it will go through. But this document, this new draft, challenges and tries to put a lot of good order in how this is effected. So I think I've captured the essence of the changes in the new draft. I'm happy to hand back to the chairman. Wilson, thank you very much.
Thank you very much, Architect Waititu. I know I was on your case for time, but this is definitely a very core part of our industry. So yes, I think one of the things that we're experiencing now is a lot of queries on the areas that we've discussed. And as I mentioned earlier, these were just the 4 main thematic areas we felt as an association wanted to touch on. But of course, I can see from the Q&A, there's a lot more of interest on various other sections. So we may not handle each and every question, because on Q&A, we already have about 30 or so inquiries, and also in the main chat area. But I'll pick a few, and the rest will actually be, since this is a recorded session, we'll be able to have all of this documented and ideally sent out to all participants in terms of responses from the panelists and the drafting team. So at this point, I'd like to thank all the panelists for their presentations on the key areas of variations, extension of time, payments, and dispute resolution. And I would like us to get into the Q&A session, which most people have been waiting for. And I would like to start off with one comment which started right at the beginning. And I think this one I would like to target, I would like to pose it to the chair at QS Cairo Bashir. It's from Andrew Wahome, who says that the document does not include AAK as a stakeholder to this document, and the engineering profession is clearly left out. And the document recognizes only the architect and the quantity surveyors as the consultants. Engineers need to be included in this document, and since the document only allows architects to issue instructions, we do know that engineers also issue instructions. So how are we going to handle this? So, QS Bashir, can we talk about the inclusion of engineers, and I think to cater for everyone else, the other stakeholders who may not have been part of the initial process? QS Cairo Bashir? Okay, seems to be disconnected. Maybe QS Moim, I think I can handle that, seeing as you're in charge of the drafting team.
You can hear me?
Yes.
Yeah, I'll do a quick one. First of all, there is no harm in defining who the engineers are and putting them in the document. But remember that this is a contract between 2 parties. That is the contractor and the employer. And anybody who is going to be included in the document should actually have a purposive law, so that if you say, for example, you put the engineer, you require to be saying in certain clauses for like instructions to the contractor, do you wish to be saying that for structural works or civil works, for example, you would be saying the engineer shall issue instructions to the contractor. Since this is a document in administering a contract between the contractor and the employer, we found that as long as we have said that other consultants can be appointed and be given delegated authority to even issue those instructions clearly by the architect, we did not envisage a situation where you would have instructions flying from left, right, and center. You have the mechanical engineer instructing the contractor, the electrical engineer, and all structural, civil, all of them giving these instructions, so that because all the work of engineers is completely intertwined with design and making sure that the design is executed on the ground, it means anything they are doing, the architect is there. And if we have a central person being the architect issuing instructions, we shall avoid confusion. But like I have said, we can put them there, but for what purpose? Because we still wish Like remember, I said when I was highlighting our brief, to retain the core and the character of this document, where we have got one person, one sheriff, who, for example, issues instructions and delegates to others. So even without harm, you can see the kind of confusion there would be if we introduced all sorts of engineers, including IT engineers today, to be included in the document, yet they have no role really in administering the contract per se. I hope that is clear, although I say we can include them in terms of definition, but what shall we do with them after including them? For the QS, I know people ask, everybody knows, even in corporate business, accounting and legal services, which I would say this is what the QS gives, this is always separate because of being, first of all, is an analytical thing, and it is not part of the design that can be incorporated in the work of the architect, and therefore you need those instructions. I think I don't want to go beyond that unless it is not clear. That is the only reason. Otherwise, you can put them in a document. There would be no harm.
Can I, to the moderator?
Yes, Kioskaro.
I'm very sorry, I went off air due to technical reasons. And yes, I know there is a question that Mohammed posed, maybe Madenga has answered it. Is it the one Madenga was responding to?
Yes, he's responded to it quite well.
Well, quite well, but if you can give me just a minute to say that whereas what he said is correct, Mr. Wahome's observations were valid, and that is actually what had informed the further comments that have been put in the draft that will be discussed at a later date. The engineer, being a key player in the contract, also deserved an equitable recognition in the contract, just like the QS and the architect are concerned. I know there is a solace of the statement that everybody else is working under delegated authority, but there could be instances where, for example, the engineer in the future, as I see it, where the engineer will actually become the person in charge of a project if it is predominantly engineering. So I would be strongly advocating that yes, we include the engineer, just like we've said, the architect shall be so and so. We say the engineer shall be so and so. But that engineer, we shall define, this is engineer doing the structural and civil works for the building. Because even if you look at a contract, strictly speaking, about 50% of the value of a contract would be going to engineering work, structural or civil. So why is it that you cannot give that particular consultant playing that role the due recognition in the contract? Thank you.
Thank you, Chairman, and thank you very much, QS Mathenge. I think I'll just read one or 2 points from, there's one from Felix Dollar who notes that most of the work has been done, and he's actually volunteering to be part of the team that fine-tunes the document. So thank you very much, Ndolo, for that. For immediate past IQSK Chair, Andrew Mandere notes that unless it's an emergency, he suggests that all variations with a financial increase be notified and approved by the client before being executed. What's your response to this, Senator Kasanga, given that you're handling variations?
Thank you so much, Mugambi. I actually agree with the person who said that it was Mr. Ashindu. Something I was also trying to catch up with the comments. I do agree that it's best if all variations are communicated and get the consent of the client. And this is simply because of all the disputes that we have seen arising out of variations. A quick answer for that is yes. And I want to say in the current proposal, there has been a lot of emphasis on the consent of the client to be sought at all times. In fact, clause 29.11, which reads, except as expressly stated in the contract, the architect shall have no authority to alter or amend the provisions of the contract. Oh, sorry, not there. Oof, sorry. Under clause 29.2, the architect may issue instructions requiring a variation, and he may approve in writing any variation made by the contractor otherwise than pursuant to an instruction of the architect, provided always that such instructions do not change the object of the contract, shall not be issued without the consent of the employer. There's a lot of emphasis on the consent of the employer at every stage of variations. Thank you.
Thank you very much, Senator Kasanga. Just one more item on the issue of variations. This was, I think, it was brought up by Leonard.
There was another question as well.
Yeah. Public have the clauses on variations put into consideration the Public Procurement and Assets Disposal Act 2015 that prohibit any variation during the first year of execution of works. Only on that one.
Yeah, there was that one, and there was another one also by the same person. On the issue of public procurement, I would say in an instance, no, because this is a document that is envisioned to private players, private parties, to private people of different, from different walks of life, envisioning different sizes of projects that can last a day or 2 or 3, a month, maybe 6 months, 2 years. So I don't think this really applies to the Public Procurement and Assets Disposal Act. And was Cairo and Madenge may confirm, but that's how I understand the Jbcc. And I know that when it comes to public projects, government and public and others, they usually have to draw up other agreements tied together with this for it, to work and to make sure that all acts have been canvassed in their projects.
Great. Thank you very much, Senator. Thank you.
And there's
Yes,
one
may I add something?
Yes.
May I add something on that variations?
Yes, please.
Yes, the first one is about the of course, public procurement does not come into play. This is a private document, like Senate has already said. So I leave it there. But for Queers Mandela is concerned, look at clause 30.4. There is an express provision for what Mandela is asking for. I'll read it quickly because it is one. All instructions for variations shall be copied to the employer, blah, 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 and shall be assessed by the quantity surveyor, agreed with the contractor, and communicated to the employer and the architect prior to execution. So there is a direct answer to that. It's already done.
Thank you. Thank you for that, Kies Mabenge. Now, there's something else which I believe we can actually have some input, and it's actually a long query from Tom Okech of ICPMK. And he says that he recalls that there was a lot of progress in the reviewing of the 1999 Jbcc draft document that resulted in Zero Draft September 2019, which is what we've been discussing. His comment is that what we see is a mischief in complete disregard to construction project management concepts that have been adopted in more advanced countries. The introduction of contract administrator, employer's representative, and contractor's representative is not the way to go. Construction project management and construction management are recognized and defined disciplines in construction industry. So he's asking, why are we deliberately avoiding the use on construction project management that assures the employer a single point of responsibility? Why can't we enhance the performance of construction contractors by adopting construction managers? Of course, he talks about lots of money being spent on training the youth, and we should now facilitate them through giving them work in the construction contract. So, Kies Bashi, I'm sure this is direct towards the construction administrator.
Thank you very much. I'm not sure I'm the right person to answer this particular question, except that it is actually going ahead and confirming what I had said earlier, that not all concerns of stakeholders were taken into account by the drafting team. And now what I'm saying as a JBC chairman, we should actually consider the draft that we are going through not to be the final document that is going to be published. And we should not lock out any stakeholder, for example, like Tom, who is able to articulate reasons. He can sit with us and we look at it. If the drafting teams are willing to go back and have a look at those things, that would be the best thing to go. I just, for example, also gave an example of why Borax is saying they would like to be included as part of the appointing authorities. Now, that was not addressed, and if it was, why they should not be there if Nairobi Center for International Arbitration is there? There are so many issues, and this is why I'm saying that we must keep an open mind. In so much as we appreciate that the drafting team did a fantastic job, we cannot say that what they have done is exhaustive and that we cannot be able to review this contract within the next few days if stakeholders so desire. However, like I said again, this process cannot be open-ended. And I had discussed with the chairman, with the president of AAK, that as Jbcc, we should now convene a wider, all stakeholders, another forum, now to say these issues that have been captured today, plus others that had not been considered by the drafting team. We would like to direct the drafting team, together with the other people who have volunteered to be part of it, to look at these drafts. And you'll also recall, but moderator, I had said that sometimes due to asymmetry of information, I can state without fear of contradiction that the drafting team was heavily skewed by having QSs only. And you see, I can see somebody's asking, why wasn't there an architect in that? Why wasn't there an engineer? Why wasn't there this? And I said, it was not deliberate. It's because people are not willing to volunteer. But now that people hear that this document is about to be published, they actually see we're going to be left out. And what I'm saying is that as Jbcc, we are not going to lock the door. But can those with bona fide comments, like Borax, like Tom, and like others, can we quickly have them and have them in writing so that they can be referred back to the drafting team? Thank you.
Wonderful. Thank you very much, Chair. Yes,
something, please. Can I say something on that, please?
Senator Kasanga was ahead of you, Bwana Madenge. Let her go ahead.
Okay, just to weigh in on this sensitive issue, there is a comment on the Q&A from Mr. Robert Oboch, which I particularly like. He says it is becoming evident that the need and acceptance of construction and project management professionals is picking up. He says he practices as a project manager. However, over time, he has realized the need for project managers to be more client-driven and less contract-driven. I myself take the same view. I am one of those who is very hesitant in having these project managers or contract administrators becoming part of the contract, for simple reason that the risk that it is to produce and make sure you bring a building that has been envisioned by an architect to life should still remain the central responsibility of the architect. I don't see how a project manager technically fits into that process, but I can see how they fit in when it comes to other client needs that can help now bring the whole project to completion. And I've seen this work severally. We've had projects where we have project managers who are more client-oriented, and then there's good harmony and communication, then that happens. I've seen others who want to come in to the point where you want to issue instructions. So then it brings now that problem of we are stepping into each other's toes and coming into each other's space. And yet you are just a project manager. I am the vision of that project. Under which circumstances then should somebody else who doesn't quite understand the whole thing come in to start giving instructions? That's just my contribution.
Yes, can I speak now?
Yes, QS, asante sana, Senator Kasanga. Go ahead, QS Madenge.
Yeah, I think there is something that is missing. There is a gap between the information that everyone else has and what the drafting team received from stakeholders. The question of contract administrators, project managers, construction managers in a project, there is nothing new that we are hearing. We already have those memoranda, and they were among the first in 2018. They did not even come last year. What is missing is for stakeholders to hear how we dealt with the issue in terms of, first of all, dealing with the brief that you are given about obtaining the core and the character of the JBC document, and then what will happen in the medium term as we wait for a different kind of document to be drafted. For example, I have been a project manager myself. I have been a contract administrator, even where we have an architect. But the way it works now, until we do a different document and we introduce the roles of those people in a standard document like the one we have, the one we were reviewing, because we are not really writing so that we make this a management-centered contract administration process. The way it works now, there is nothing to stop anybody, even now. And in fact, they are still using the green book with a project manager what you do is, if the project manager is an architect, you could actually simply use the same person to be the project manager. But if the employer wants somebody who is different from an architect, you specifically enter into a project manager consultancy agreement with the client, and this is communicated, and I have done it before about 3 times myself. You communicate to the parties right from tender that you shall be having a project manager, and his role during the administration of the contract shall be this, and this, and this, and this. So that in the event that he is not an architect, and we know that some of the duties during contract administration require somebody who is able to exercise a certain level of legally grounded impartiality, like an architect. We will be able to split and set out what role the project manager can actually do without contravening the law, because for an architect or a QS or an engineer, these are protected professions. And there are things, for example, you cannot do as an architect because, for example, CA 525 says you must act impartially when you're making these decisions and the other thing. If you bring a project manager who is not from the built environment and has no regulatory law that makes them understand that you are not coming here as an agent of the employer, so that you issue instructions, you assess extensions of time, you certify, you issue, you do so many things, always in favor of the employer. That is something we try to avoid, and we went through this and said, let us retain the current position where if you want a project manager, you have a separate contract, which is, and from the beginning, inform the parties, whether it is before tender or if it's a negotiated document before agreement, that you will be having a project manager whose role shall be the following. If you get one and you do that, then there are some roles of the architect he can take over from the green book that we are reviewing. All those roles that do not require that impartiality, because a project manager, a contract administrator, will come in there as a direct agent of the employer. You know, the architect and the QS and the engineers under the regulatory laws, there is that requirement that they must exercise impartiality. So that we do not want somebody who comes in and has no idea that he's supposed to be impartial between the contractor and the employer. And then you wonder, you have come in here to introduce disputes which you are running away from, because this one has no even professional ethics that require him, forget even about the law, to avoid any bias. So it can still be done, it is still being done, but let us do another document with that in mind, because it is an important thing, it is happening. For the role of, for example, the contract administrator, we know where it came from, South Africa, because of the practice there, which is rather unique. The normal thing is the design team does not do the administration of the contract. You finish at tender or negotiation, and then somebody else takes over the drawings and all the designs done by the other people, and another team continues. So it was very easy to introduce a contract administrator who was not part of the design team. And this is a person, again, appointed, and even in South Africa, he must be somebody who is from the built environment provisions by law. Here we do not have provisions by law or even what qualifications a contract administrator is or a project manager is. It is not there. We shall develop as we go on, and there is nothing we cannot do even with the current document by having those separate contracts and identifying the roles of these contract administrators and project managers. I think I can stop there.
Okay, yes. Thank you, QS Madenge. I would like to move on to the next question because there have been several questions targeting the other panelists. This one goes to Mr. Kiriba. It's from an anonymous attendee. And he says, kindly address the need for dispute boards in the new Jbcc proposal. That is dispute avoidance, dispute adjudication, and dispute review boards. And also there is a question from architect Nick Orina who asks, who caters for the cost of dispute resolution, or rather the process? And finally, Chariot talks about the qualification of an adjudicator, and is it provided that the parties can identify the adjudicator from the commencement of the project? Have you got that, Bwana Kiriba?
Yes, I have.
All right, over to you.
Okay, on the first question on addressing the need for dispute boards and dispute avoidance, dispute adjudication, and dispute review boards. So the concept of an adjudicator in the 2020 Green Book addresses the whole issue about dispute boards. I think it's just a difference in terminology. FIDIC contracts usually call them dispute adjudication boards. That's the 1999 version. And the 2017 version calls them dispute adjudication and avoidance board. So it's a difference in terminology, but the concept is the same. An adjudicator under the contract is the dispute board. On the question of dispute avoidance, first, very many provisions which some have also been highlighted today are geared towards dispute avoidance. And just to highlight two of them, the payless notice is one of the ways of ensuring that disputes do not escalate. It is providing parties to ventilate their difference in opinion. And then number two, you'd also remember what was very ably presented by QS Kipinji about a notice of dissatisfaction in the event that once an architect has issued a decision on adjustment of time, parties have an avenue to also ventilate their views on that adjustment of time decision that has been given by the architect. And just to distinguish this a little bit, let me answer the next question of whether an adjudicator is appointed from the commencement of the project. The answer is no. The adjudicator in this situation in the Green Book 2020 is appointed as and when a dispute arises, what is referred to as an ad hoc board. This is an issue that was considered by the stakeholders, and the stakeholders agreed with the merits of having an ad hoc dispute board as opposed to a standing dispute board, dispute adjudication tribunal. And some of the merits, some of the demerits of a standing tribunal is that they are expensive because an adjudicator being appointed at the beginning of the project would have to be on a retainer basis. And sometimes you may appoint an adjudicator at the beginning of the project, and then a dispute that arises later requires a different competence. So there may also be a competence issue. So amongst many other factors, it was decided that a standing board, an ad hoc adjudication tribunal is the best way to go. To go back to the question of dispute avoidance, for that reason, we can, the contract does not have the inherent benefit of dispute avoidance through an adjudicator, as would be the case with a standing DAB or with a standing tribunal. On the next question about who caters for the costs, if you look at clause 44.17b, which relates to adjudication, the general principle is that both parties bear the cost of the adjudication equally. And then it moves on to say that the adjudicator has the power to make a determination on costs. So you may go through adjudication, and then the adjudicator decides, okay, by the way, the decision that has been referred to me is frivolous, which ought not to have been brought by any reasonable person. So for that reason, the person who referred this dispute is the who referred this dispute who has lost is going to cater for the cost of these adjudication. In such situations, then costs are handled differently. You will notice that the contract does not speak about who caters for the costs of the arbitrator. That is very intentional because the cost of the arbitrator is ordinarily dealt with within the arbitration rules that are going to be chosen by the parties. If the parties decide to go with CIAB rules have that. If the parties decide to go with NCIA rules have that. I don't know whether there is a question on the other question by Cheriot about the qualification of an adjudicator. The contract expressly states that the adjudicator should be suitably qualified. Now, there is a problem of stating the qualifications of an adjudicator from the word go through a standard form template, because in one dispute, you may require this kind of an adjudicator with these competencies. In another dispute, you may require an adjudicator with these competencies. Some projects vary. So for that reason, providing suitably qualified means that on a circumstance by circumstance basis, you're going to appoint the adjudicator who's best fit for the dispute that lies ahead of them. And there is sufficient jurisprudence though in arbitration, not in adjudication, that shows that an arbitrator can be challenged on the basis that they are not suitably qualified to handle a dispute. I believe those are all the questions that I had, unless there's something that I have left out.
I think, yeah, you've addressed them well.
May I add something to that?
Yes, sure. Go ahead,
yes.
Kenji.
Yes, thank you. And the advocate has given a very comprehensive answer. But what I would like to add is that a DAB is not meant for dispute avoidance. Remember, what goes to a DAB is a dispute. It is a dispute adjudication board. So a DAB handles a dispute. It is meant to stop the escalation of a dispute and to reduce the time that is spent, the resources that are spent in a dispute, by resolving it early and when it is still small. Dispute avoidance cannot be achieved through a dispute resolution mechanism, because a dispute resolution mechanism, by the very name, is meant to resolve a dispute which has already occurred. The way to avoid dispute is a proper administration of the contract and user awareness. The users, the two parties, and of course even their consultants need to be aware of the various provisions of the contract so that they respect them and they adhere to them, and also to understand the consequences. Because if you look at why disputes arise in a project, it has to do with psychology of disputes. And there are various reasons why people bring disputes into a project. And so when that is understood then by the contract administrator, the administrator will be able to guide the project through the document, the contract, which is meant to allocate risks, give methods, give timelines, give reasons, give consequences of taking certain actions. So the administrator will be able to navigate through all that and balance the rights and obligations of the parties, so that any party who wishes to bring a frivolous claim or dispute will know from the outset that they do not stand a chance and they stand to lose. So that's how to avoid disputes, not through dispute resolution. Thank you very much.
Thank you, Kios Ketenji, who's also Advocate Ketenji. I'd like to direct the next to Architect Waititu, and this is the issue of BIM. There's an architect from Joel Oyuga, and he asks, can you consider introducing BIM-related deliverables like BIMX as instruments of contract? This enables complete understanding of a project before it starts. And there's further clarification on this BIM matter by someone who goes by the name User, and they say that the BIM protocol intends to minimize variations via the BIM design process, and they are requesting that we add it to the appendix. and it has been written into the contract at the outset, otherwise it is not effective. And that's, of course, from the UK. So what's your input on that, Architect Waititu, as we look into issue of advance payments also from Felix Ndolo? Maybe touch on BIM first, then we go to the payments.
Thanks a lot, Wilson. The problem of all electronic documentation in this country is the legal framework which surrounds it. Nothing really prevents you from having, if you go to the precedence of documents, in the contract documents, in clause 7, it actually spells out all the documents that are required upon signing of and which constitute what the contract will be. So BIM indeed comes and makes things easier, but the problem is that the legislative framework, I'm not very sure that it has been completely and comprehensively it has been done properly so that it is able to be admissible in a contract such as this. Having said that, I do not see why it should not be put in the appendix. Yes, this is something we can really look at and see how we can operationalize, especially in this time of COVID, when you want all your documents to be in soft copy. It is a way to go. Thanks.
Thank you very much.
Moderator.
Yes, Basha.
Can you please allow me just to say something about the advance payment? And I would like particularly QS Madenge. You know, there are some certain clauses from clause 33.13 to clauses 26.135, which actually stating that the employer is liable to pay interest for delayed advance payment release. These are the kind of questions which I wonder whether, for example, the employers were consulted in that particular issue, because in itself, it looks very punitive. First and foremost, we should not make advance payment contractual. It is a matter that should be agreed between the two parties. And if, for example, the employer is going to consider advance payment, it should be put in the tender document so that by the time the contractor is tendering, they are aware whether there is advance payment or not. So I would like Moi Madenge probably not to comment now, but closely to look at clause 33, 1.13 to clause 26.135, which I doubt if any employer would actually with that clause. Thank you.
Can I respond quickly?
Probably, okay, fine, you may.
Yes. No, it doesn't need to wait. I can say this. You have, Mr. Cairo has put it correctly that if there is going to be advance payment, it is known right from the tender document, so that if it's a tender, if not a negotiated contract, you already know that as the parties enter into commencement of the works, for example, the contractor expects that the first certificate shall be financed through advance from the employer. You know what that means. It has become a term of the contract, right at the point of signing that contract. Once you voluntarily put your hands to such a situation, you cannot later say that it is not an obligation that should be met with the sanctions, where the other party who was expecting you to behave in accordance with the agreement that you have, that you are saying it is punitive. It is very clear. What would happen is, the rationale here is, if the employer has not provided the advance that was agreed on, what does the contractor do? The first thing is, should he stop moving on with the work, or what is supposed to be happening? Supposing he decides he's going to go on with the work, where will he get the money? And yet, we are aware that a lot of contractors, just like any other business, depend on running to the bank where they do not have cash. So there is a promise, it is reduced into a contract, that you shall finance from the beginning by giving advance. Then you don't do it. So the contractor may choose to go to the bank and borrow that money, so that while he waits for you to make good, although we have made provisions on other ways of dealing with this, he is now financing something that he never set out to finance when you, in quotes, misread him into signing a contract where you made a promise you are going to give this advance. So if I can stop there, I think there's more I can say, but you can see what it means. A contract term is a contract term. But like Cairo says, if it is done before tender, that is the best. Instead of when you are starting, and then it creates a gap as you now start to commence the work. It is a contract term once it is agreed and signed before. And therefore, it is just like any other payment, where the contractor will have to resort to borrowing because of default on the part of the employer. It's not punitive. It's a part of the contract term once the parties agree.
All right. I think just one other thing on that, Wilson. 33.1 is also very clear that the subclause shall only apply if an advance payment is provided for in the appendix. So it is this clause only kicks in if indeed you had agreed on an advance payment amount before.
Yeah, correct, Monsieur. Very well.
Yeah.
All right. We have a question from Julius Mutunga, and this is to all the panelists. And he says, or it's more of a suggestion, that we need to introduce qualification of the arbitrator so that those appointed in the building industry are in compliance with the Arbitration Act 1995. Otherwise, we will run into challenges. So I think in terms of dispute resolution, maybe QS Kipenji can talk about it, the qualification of the arbitrator and the suggestion of it being actually enshrined via the Arbitration Act.
Thank you, Chair. It is difficult to specify the qualifications of an arbitrator because an arbitrator is chosen by the parties according to the judgment of the parties. And the parties have the freedom. There is what we call the freedom of contracting because even the choice of the arbitrator is part of the contract. For construction disputes, the parties can actually, during contracting, because they have their contract, specify who would be the arbitrator in case of a dispute, knowing very well the nature of their contract, knowing very well, because not all construction contracts are the same. There are some that have more of services. It could be a civil contract predominantly, where they may want a civil engineer. It could be a contract of just remeasurements and accounting, where they may want a surveyor specifically. It could be a design-oriented a project where they may specify an architect. And so it is not possible to specify an arbitrator right from the beginning in the contract. And the moment you say that the arbitrator shall be either 1, 2, 3, 4, the parties can later disagree because one can insist on one and the other can insist on yet another one. The contract provides that the parties shall concur anyway, and in the absence of concurrence, then they will refer this to an appointing authority, which has the capacity to understand the dispute and therefore appoint a suitably qualified arbitrator for that particular dispute. In terms of compliance with the law actually does not specify. And therefore, any appointment by an appointing authority, any arbitrator who is agreed between the parties does comply with the law. That is the Arbitration Act 1995. So there's no risk of going contrary to the law because the law gives parties the freedom to choose the arbitrator. Thank you.
Can I add something?
Yes, Kies Madenge?
Yeah,
thank you.
Even under that act, it is not unheard of for parties to challenge an appointed arbitrator either through the appointing authorities. Well, when they are appointed by appointing authorities and they appoint a person who does not have the competence in the area of the dispute. I have personally done it over the last nearly 30 years, I think twice or 3 times, and we have succeeded. You say, this is the nature of the dispute. The appointing authority already has notice of what the dispute is about, but they have appointed a person who is not going to achieve what arbitration is supposed to achieve. And very many times, it is normal that you can actually get away with that and say, this fellow is not qualified. And we have done it. And I remember even 6 years ago, I did it myself. They had appointed somebody who has nothing to do with the construction industry to deal with a dispute on construction matters. With a new, you know how we have lawyers now. I'm not saying there's anything wrong with the lawyers. I'm one, but they may appoint somebody without knowing what it is. And you have the right under that act to oppose anyone you think is completely unqualified to handle your dispute.
Okay, thank you, QS Mabenge. There's another question before we start looking at winding up, because I want us to wind up in the next 10. There's a question from Architect Tom Sitati, who says that the term suitably qualified person, that's in quotes, appointed by the employer, should circumstances dictate, to act as a CEA or contract administrator, could be anybody with any qualifications or even no qualifications. And he's asking, did I miss something else? Did I miss something elsewhere in the document? And I think, QS Ketenji, you may have a voice on this.
Thank you, Chairman. Suitably qualified depends on circumstances. And like it has been said by QS Cairo, QS Mathenge, in fact, every panelist has referred to the suitability of the contract administrator when it arose, and also said by Sylvia. It all depends on what this contract administrator is and the duties, because the duties are not defined in the contract. So the suitability would depend on what the contract administrator is appointed to do. The contract administrator, remember, is a title which is not defined, and therefore when it is introduced into a contract which doesn't have that term, it will be defined in terms of duties. Presently, we use employer's representative or something like that, and therefore there is no hard and fast rule of defining who that will be, and it is left to the parties. And once a role is given, then that role should be synchronized with the contract. It is possible to appoint a contract administrator who takes, and then the document is amended, and the contract administrator takes certain duties of qualified persons in certain areas in the contract, and conflicts are brewed in that contract. And it is possible in terms of the contract, for example, where the contractor can oppose the appointment of certain persons, to actually oppose that, or to make claims which are based on maladministration of the contract because of lack of competence. So, and that's why I said it is necessary that the users of the document are educated on it, and they are made aware of the roles of all the parties, so that when they make such appointments which may be supported by the contract, but which require certain skills, they do not appoint people who would bring problems to contracts. Thank you.
Thank you, Chris Ketenji. The next will be something directed to the JBCC chairman, QS Cairo Bashir, and that is, there are two questions. I think one is something that maybe you can shoot from the hip right now. And he's from Justice Otwani asking, kindly advise on the deadline for submission of comments. I'm sure this, of course, can be directed through AAK. And the second is, when can we expect the next amended draft incorporating current comments to be ready?
I would propose that we have the comments within the next 7 days, because like we said earlier, and like QS Madenge stated, this process has been going on for the last 2 years, and it cannot be an open-ended process. We really want to, it was our hope that we were going to publish this document by the end of June. We did not meet the deadline. So I would recommend to this, I will be recommending, discussing with my JBC team, that we give stakeholders another 7 days within which to table issues which they consider to be very hot.
which then will definitely be referred back to the drafting team. And maybe the drafting team within the next 14 days, they can look at them and incorporate, we say closed. Thank you.
Yeah. Can I add something to the voice of Cairo, please, Mr. Cairo? Can I add something?
Yes, Malenge.
Yeah, that suggestion from Mr. Cairo is very, very appropriate because we have been waiting for responses from to the zero draft that we sent. So if you are going to give notice for institutions and anyone else who have comments to do it, I would suggest that probably give them 30 days. Because some of them being institutions, they may require to even have a seminar like the one you're having today. Because like now, AAK has done what nobody else has tried to do. Actually here, let their members understand what this draft zero thing is all about. And in doing this, I will ask that once they are given that 30 days, those making the policy and directions to say nothing else will be allowed in to interfere with any completed draft. But even as they do this, like I said, there is an information gap. Please, once these documents come, if they are going now to be, the repository is going to be Jbcc because that can happen, we will want to compare with what we have because we have tons of documents so that any repeated comments, we will be saying for these ones, we already dealt with these issues and this is how we dealt with it. For these ones, it is like this. For new ones, we shall of course say, yes, what do you want us to do? Do you want us to deal with them and come back to you, or how do we move? Otherwise, we will continue having people sending all sorts of information. Even if I saw, for example, there is one institution that sent, I think, 3 times, 2018 and now last year, and I think somewhere in between as soon as we finish presenting in on 29th November. So it is us who will be able to actually advise this. We already have this. Can we deal with it the way we dealt, or do you want us to do a little more? So that we compare what is coming in new with what we already have. For example, that thing of Tomo Ketch, we already dealt with that issue in 2018. So let us be able to coordinate this the way it has been coordinated before by Jbcc. And I can tell you, Mr. Cairo put the fire at our shares. I'm still burning. He was very frustrated at one time because he would even call me at night about raising. That passion, I know it was very useful because when fatigue comes in this, it can happen. So please let us give them 30 days so that they have enough time and we have enough time to compare what new has come or what people are saying is new, yet it may not be anything new. Thank you very much.
But just a comment, moderator. QS Mabenge, if we give the stakeholders 30 days, yes, how much time then would the drafters require? Because again, you don't want the drafting team to take a year because of their said fatigue. To give us
you will be the driver. Sorry, moderator. Sorry.
I propose we hand over off camera. I'm sure that's something we can do.
Okay, so thank you.
It is a very hard driver.
Agreed.
Asanteni. I think we've addressed most of the queries which are there. And for those who, there are several questions still coming in, we'll be able to respond to them, of course, through the panelists. But at this point, in the interest of time, I would like us to close, and I'll give each panelist 30 seconds just to give a closing remark. Thereafter, I'll invite AAK CEO Jacob Mwangi to close the session with a vote of thanks. So let me start with Senator Sylvia Kasanga with her closing remarks. 30 seconds.
Thank you so much, Mugambi, moderator, and thank you for the good job. And also just to thank my fellow panelists. This is also a learning opportunity for all of us, and I'm so grateful to AAK for putting this together. I've always said that this is how our seminars and CPD programs should be, like, where we are all constantly learning and improving ourselves as architects, quantity surveyors, and all the other stakeholders. I'm very grateful for this. And just a note to our fellow architects out there. Architects, we must remember, at being at the helm of our construction contracts, we must not cede that position, and that will only come by how well we apply ourselves and how much we follow the law, because a lot of us are dropping the ball when it comes to some of these things. I'm only being very honest based on the disputes that I've seen in front of me. So let us not cede that ground, let us stand firm and strong, and let us grow in our profession together. Thank you.
Thank you, Senator Kasanga. In fact, Cairo's tablet fainted. Thank you very much. Next, I'll have closing remarks, 30 seconds from QS Nyaga Kipenji. Karibu sana. 30 seconds.
Thank you very much, Chairman. I would like to thank the AAK for organizing this webinar, which has been very useful. I thank you, Bona Moderator, for moderating it very well and keeping us to the time, especially your initial briefing, which mentioned your whip, and you've whipped as well. I thank my fellow panelists for keeping to our initial agreement on time. I thank the audience for raising very pertinent questions, which will contribute to the improvement of this document. And I would like to observe that today we have dealt with 4 thematic areas, and there are many other areas to address in this contract so that we are well grounded in it, being the contract administrators in the industry, and that this should be the way to go to understand our contracts better, because there's always something to learn. And so I would like to request AK, QSK, IEK, and others to organize webinars so that learning contracts becomes an area of continuous professional development, so that we become better managers of the industry. Thank you very much.
Sana QS Kipenji. Next, I'll invite Advocate Simon Kariba to give his closing remarks. 30 seconds. Karibu, Simon.
Thank you very much, Wilson. I would like to take this opportunity to thank AAK, the participants, Wilson for moderating very well, and all the panelists. I think my only closing remark would be that the document, I am certain that the document that shall be published will be a much better improvement of the 1999 draft. And I would request the industry to embrace it and to use it for purposes of the projects going forward. Thank you.
Thank you, Simon. Architect, before I go to the JBCC directors, QS Mwai Mabenke, your 30 seconds. Karibu.
Thank you, moderator, but that's rather mean, because I was going to make an application first that I get 3 minutes if it is okay. I know that is outside the protocol, because there were some sentiments expressed by even some of the panelists when they were presenting, and I thought if there was a chance in 2 minutes, I could highlight them so that people don't go away without knowing what happened. But I'm not saying that you must do it. Otherwise, I thank you very much, and I expect that if you are directed by the stakeholders, after receiving comments from various stakeholders, that we go back and adjust the document, because we expect there will be adjustments. I will be one of the first one to say, like we worked from 10 o'clock during the day, 10 o'clock in the morning to 10 o'clock at night, we shall still do it again, because we can't start a journey that we shall not finish. And I'm very, very happy that AAK decided to have this webinar, because we've been lacking in coordination of the next step to go since the zero draft was submitted. So you look like you have denied me a chance to touch on the sentiment on something I want to clarify, but I'm not trying to second guess you.
Thank you, Kios Madenge. Yeah, I have to steer this ship.
I get it. Thank you very much.
Yes. Architect Mushiro Waititu, your closing remarks.
Thank you very much, Bona Moderator. I'd just like to thank AAK for putting this together. This is like the chairman, Bona Kairo, has been saying, it's been a journey of 2 years plus. It has really taken a lot of opinions. What I'd like to say is that what we are trying to do is put together a document for posterity. Indeed, the document, by the time the 1999 document was being done, there are professions which did not exist at all. The project managers, etc. So the nature of our engagements usually is that people want to cocoon themselves and think that you want to have this document which is only for QSAs or for you want only a document which champions project managers or architects, or this document there is no, I like the sentiments which were expressed by someone, Lawrence Bogwa, that the contract administration, project supervision, and project management are not synonymous. They're different things. So indeed, the architect may not like writing minutes in a meeting, but you should not take away his right for somebody to come and play around with his design. Those are two separate entities completely. So I think there is room for a lot of that. And as we continue having this to and fro, our profession is being proliferated by quacks. I'm sure we've all sat in projects where you're brought for an employer's representative who's an accountant or a lawyer or somebody because he built his house somewhere. He's now the expert for the organization. So as we fight over this, let us look at putting together a document which is for all of us. It encompasses all our, and we, after 10 years later, we are still saying that this was a good document. Thank you very much.
Thank you very much. That's good input. And last but not least, let us have the final remarks from the JBCC chairman, QS Kairu Basha. Karibu sana.
Thank you very much, moderator. It will be very hard for me to make my comments without repeating what others have said, but I will try. First, I thank AAK, the panelists, and of course, you, the moderator, you manage time very, very well. But I would like to harp on one point that Waitito has said. We are preparing a document for posterity, not for now. I would also want to appeal to the drafters that as we prepare this document, let us not localize it too much. We are aware that even the Green Book as it is being used in the East Africa region, Kenya, Uganda, Tanzania. We want it to be used in the Sudan. We want it to be used other places. So I think I would propose that the mention of Kenya law, we leave it out and we make it like a kind of a regional document. That is a vision that we should have, because this will also be good for the business of AAK. I would also want us to prepare a document that can be able to be acceptable to engineers when the project is predominantly engineering, not necessarily like energy projects. Like, for example, if you have a housing project and they decide to do it in phases, and phase one, they probably want to do civil works, it will be predominantly engineering. And you know that the correct person to supervise that project will be the engineer, not the architect. Can we be flexible? I know QS Madenge said that they want to retain character of the Green Book, but I keep on saying that once you get an opportunity, even if we say they review, sometimes the difference between reviewing and rewriting can be a gray area. So let us not put ourselves in a straight jacket saying that we want to retain the character of the Green Book, including retaining 45 clauses. No, let us actually have an open mind and let us accommodate the sentiments that have been expressed by other stakeholders whose interests were not taken into hand. Otherwise, I would like to thank the drafters very, very much. It's a lot of hard work. And like they said, once it looks like, although this is a forum for AAK, I'm very excited to see that the participants included a diverse membership from the other stakeholders. And this looks like it's almost like a sign that now, for once, people have read the document. The challenge with most of us is that we wait until the last minute when there's something like this to read the document. I doubt that many of us had actually read this document before they heard about this webinar. So I'll encourage you to read it even further. Kithinji has said you have tackled only 4 thematic areas. There are other areas that are very crucial to our contract here, and I believe all of you will do it. As chair of JBCC, we shall do what is within our means to make sure that we deliver a document that is one of the best in the region. Thank you.
Thank you very much, QS Basha. Thank you very much to all the panelists. Before I close off the session, I'll just invite the AAK CEO, Jacob Mwangi, who has actually been pivotal in setting this up and also part of the review process, to give some closing remarks. Then thereafter, I'll formally close the session. Karibu, Jacob. Unmute your mic, Jacob.
Thank you very much, Wilson. Mine is to thank all the eminent panelists that we had today for making this possible, and all of us and all the panel participants today, because this has been one of the most vibrant webinars that we've had in AAK in the recent past. Thanking the chairman of Jbcc, Mr. Kairo Bashir, because he has steered this process for the last 2.5 years, and we're nearing the end of this whole process. Very thankful for your effort. And to thank all the other panelists, Senator Sylvia Kasanga, QS Moi Mathenge, QS Nyaga Kifinji, for you, and also Architect Mushiri Waititu for your input, and also Advocate Simon Kiriba. Thank you for your effort, for your support also, because you've also gotten your support for yourself, from yourself as a person, and also from the firm that you represent, that is Bowman's. They've also been very, very supportive to this process since the beginning. I also want to thank the participants today, because as I said, this has been demonstrated the importance of this activity to the industry. We've had more than 200 participants today. That says a lot. And of course, the level of engagement that we had shows that there's a lot of interest in this activity that we're running. I know we didn't have enough time to deal with all the comments and questions that came from the participants today, but you can assure all that all is on record, and we'll be presenting them to the paneling, to the drafting team and the Jbcc board as we go forward. So thank you all. I want to thank also the president of AAK, Madam Mugure Njedu, probably she's out at the moment, for guiding this process for this meeting today, and also to you, Bwana VP, for ably moderating this session. Thank you all, and thank you everyone, and Asanteni sana.
Thank you very much, Jacob. Ladies and gentlemen, that brings us to the end of this webinar, which was discussing the Jbcc proposed amendments. As you've seen, this was just touching the surface, and I'm sure from this point, it's going to be positive development of and improvement of the document. I would like to wish you all a blessed evening, and as much as the lockdown has been lifted, let us stay safe and take care. Asanteni.
Thank you.
Thank you.
Bye-bye, everybody. Thank you.
Bye.
Asanteni. Kwaheri.
Bye, Kwaheri.
Thank you, everyone.
Bye.